Whenever you're ready.
Good afternoon, and may it please the court. My name is Hannah Garland, and I'm a third-year law student at the University of Washington, appearing on behalf of appellant Cole Spencer. I'd like to reserve 3 minutes for my colleague, Ms. Fitzmaurice, on rebuttal, and I will try to keep track of time.
All right, I'll try to help you out, but keep your eye on the clock yourself too.
Thank you, Your Honor. On March 21st, 2018, Officers Pew and Rosema violently beat and severely injured Cole Spencer, an unarmed passenger in a routine traffic stop. This is not disputed. The body camera footage shows that once Spencer was on the ground, Officers Pew and Rosema continued to brutalize him. Starting only 36 seconds into video B, which is Deputy Macklin's video camera footage, the following violence against Spencer can be seen occurring. Rosema knees Spencer in the back before then punching him in the stomach while Pew holds down his arms. Pew then slams Spencer's face into the ground at least 4 times, strikes him in the face with his knee at least twice, chokes him to unconsciousness, and grinds his face into the gravel. The angle of Deputy Macklin's body camera footage indicates that he is either sitting or lying on Spencer at this time.
One thing that seemed hard to discern from the videotape was what point exactly the handcuffs were placed on both arms. What does the record show as to that point, and where in the sequence of strikes from the officers does that event fall?
So Spencer is handcuffed at about 46 seconds into video D, and it takes about 4 seconds. You can hear on the tape that they're saying clasp it, referring to the handcuffs. And then after that point, you can see on video D that his handcuffs are cuffed behind his back.
And then, and what occurs after that point that you challenge as excessive of the things that you've said?
Yes, so after that point, Officer Pew kneels on his back for at least a minute, while Deputy Macklin is still also physically restraining him.
So did the strikes by Pew of his head into the ground occur before or after the handcuffs were on?
That occurred before he was handcuffed.
Are there any cases that squarely say that law enforcement can't use that type of force when a suspect is still resisting?
So first, I just want to address the question of resistance. And so we would contend that movement is different than resistance, and it is a dispute of fact whether Spencer was actually resisting during the point where they were assaulting him, and taking the facts in the light most favorable to Spencer, which we must do at this point.
Well, but the relevant fact under Hernandez is not what Spencer had in his head, whether he thought of himself as resisting. It's whether what a reasonable officer would interpret as resistance. Now, it could be that no reasonable officer would have interpreted that as resistance or the actions revealed, but you've just said they couldn't get the handcuffs on at the point that some of this earlier violence occurred, and he's clearly resisting in the objective sense. He is making it difficult, let's put it that way. His actions are making it difficult to put the handcuffs on. That looks like objective resistance. If that's happening, an officer gets to use force in order to get the hands behind and the handcuffs on. So explain to me why, from an objective point of view, that way, you have a triable issue.
Yes, so we do believe that a reasonable jury could view the video camera footage and believe that Spencer was unable to comply and was choosing not to comply. And as you said, there is the chance that the reasonable officers may have believed that was resistance. Nonetheless, once Spencer was handcuffed and laying prone on the ground, Pew still drove his knee into his back for over a minute. So even if the jury finds there was resistance during that initial interaction, Spencer was not resisting. He was still in prone on the ground while Pew drove his knee into his back.
So what would be the clearly established authority that would say that you can't have your knee on the back of someone after they're handcuffed?
Yes, we are relying on the law in the County of Riverside for that.
But in Lalonde, I mean, the officers were putting enough pressure that, you know, there was a reaction. Do you have that here?
Yes, in the medical records, it shows that Spencer fractured 2 parts of his spine, in addition to other injuries, including fractures to his mesobone, his septum, and his left eye socket. So I believe that you're right. Part of the holding in the law relied on the occurrence of serious injury that, unlike in Cortez Luna, was not just said, I had a headache or I had back pain, but here there are medical records, and he also was rushed into emergency surgery because of this incident. So I do feel.
So if we were to remand this case, then at what point would you say is the turning point? We'll have to explain to the district court and for the trial counts on both sides what issues are factual disputes to be tried before a jury and which ones you've conceded. So is that turning point at the 46 seconds video D part when he's on the ground but before the handcuffing, or is it at some point prior to that?
Thank you. It is unquestionable that that line was crossed at that 46-second point when they then kneeled on his back after he was handcuffed. However, there's also substantial evidence that a reasonable jury could find to conclude that they used excessive force right from the beginning of this incident when Officer Rosema wrenched Spencer's arm behind his back. And part of the reason that it's so hard to find that line is because it is a fact-dependent inquiry. And we believe
but there's no dispute. Is there from the record, or can there be any reasonable dispute that there was some resistance to the handcuffing in the beginning? Just pulling away, even taking his version, right? He did pull away from the officer who was trying to handcuff him.
I'm sorry, I'm not sure which part you're talking about when he is already on the ground.
Well, you're saying that if we were to remand, it's an entire reversal, that the whole case goes to the jury from the moment that they attempted to handcuff him on. Is that, am I correct in understanding that's your position?
Yes, you are correct that we believe the jury should have the opportunity to hear all of those facts and decide in disputes of fact using the Graham analysis. We feel very strongly that
on this record, can there be any reasonable dispute that he initially resisted? At the point when the officer was trying to handcuff him, even by his own version, he pulled away, right? As he said, to create some space or distance.
that is correct.
So how can it be from the beginning? I'm trying to figure out if you got your ideal, it can't be from the very beginning, right? Because there's got to be some concession that there was initial resistance. So at what point do you get to go back and put this case before the jury? If it's not the beginning, give me an alternative point.
Thank you. So the reason we do think it could be the beginning is because resistance itself is not necessarily dispositive in the Grimm analysis. And so even conceding that, yes, there was initial resistance, such as there was in the Lond, excessive force was still found when they looked at the totality of the circumstances and saw that force was used beyond what was reasonable to effectuate an arrest. And we believe that's the same situation here, where even if we concede that there was initial resistance when Officer Rosema tried to handcuff Spencer, the use of force escalated in such a way that even from that point, it may be found to be excessive using that analysis. I do see I'm coming up short on time. Are there other questions, or may I reserve?
All right.
Thank you.
We're down to less than a minute, but I'll put 3 on the clock.
Thank you, Your
Your
Honor.
colleague comes back up.
The 2 minutes.
All right, you're splitting time. And Ms. Critch, you're taking 2 minutes and reserving the remaining 8 for Mr. Linval, is that right?
Yes, Your Honor. Good afternoon, judges. My name is Anna Kreitz, and I represent the Maricopa County Sheriff's Deputies, Schall and Macklin. Mr. Linval here represents the Mesa police officers. I begin by saying I believe the deputy's briefing does a very clear job explaining why the district court's ruling should be affirmed as to Shao and Macklin. But beyond that, I will say that Appellant Spencer doesn't argue that the sheriff's deputies' actions constituted excessive force in their own right, and he does not even analyze their conduct under the Graham factors. Moreover, qualified immunity protects Shao and Macklin in this instance. It was Spencer's burden, but he can't point to a single case that says officers can be held liable for using reasonable force to respond to de-escalate a fight between law enforcement and a resisting suspect.
Well, Maya, the way you've said it, you viewed the facts in the light most favorable to the officers instead of the other way around.
Your Honor, I don't believe it can be meaningfully disputed that Mr. Spencer was resisting during this interaction. He pled guilty to aggravated assault to an officer during this interaction, a felony. He also admitted in his original opening brief no fewer than on 3 occasions that he was resisting arrest. He was quite candid. He admitted it on page 11, and then again on 13, and then again on page 17. So I don't think it's a disputed fact that he was resisting. But beyond that, Spencer relies on the integral participation doctrine to find liability for Shao and Macklin, but there he does not show how Shao and Macklin's conduct rises to the level of fundamental involvement under Ninth Circuit precedent. And here I ask the court to consider the practical implications. What would Spencer want Shao and Macklin to do in this situation? They cannot respond to a roadside scuffle involving law enforcement without being treated as armed backup and integral participants. So they must either drive by and leave law enforcement in need of aid and just keep driving, or stop, but before they respond, engage in a hindsight-focused analysis. Who struck the first blow? Were any acts of excessive force committed prior to us arriving? For what crime are you investigating this man? It's simply not the standard.